learning disabilities, and other medical conditions, and disabilities, and tricks they use to kill your case. This video covers some of the tricks lawyers and judges use to kill your case, and provides methods to prevent this from happening. This is good for people that have a learning disability or a medical condition that is not apparent by observing you. Judges have their own biases and prejudices, and because of this, do not think that a learning disability is a real disability. Trust. Do not trust them. No matter how nice or kind the other side lawyers may seem, you cannot trust them. They will use every trick they have to win. They will do their best to take advantage of the fact that you are not a lawyer and do not know that much about court procedure or the law. Why? Because 1. Their careers depend on the number of cases they win. 2. Their ego and pride cannot take losing to a person who is not a lawyer. 3. Losing to someone who is not a lawyer can make them look bad and might have an impact on their career. Plus, you cannot trust the judges. It does not matter if the judge is male, female, black, white, Asian, conservative, or liberal. Judges have their own biases, prejudices, and tricks to kill your case. Learning disability. Some of the tricks they will say. 1. Your medical diagnosis or medical records are too old. 2. Your diagnosis was not conducted by an MD doctor, but by a PhD. 3. The cost to get a new diagnosis is cheap, so you should be able to get a new diagnosis. Judges are not medical doctors. Yet, some of the things we have heard from judges are as offensive as a man telling a woman he knows what it's like to be a woman and have a professional career. You can tell the judge that you are signed up with your state's Department of Rehabilitation Services, and the judge will just ignore this fact. You can show the judge that in the American with Disabilities Act, it states that a learning disability is a disability. Please see Federal Law 29 CFR, Section 1630.2 J4III for more details. All of this will not matter because a lot of judges believe that a learning disability is not a real disability. Most of the time, a learning disability diagnosis is conducted by a PhD and not a medical doctor. A learning disability is something you are born with, and it never goes away. You want to attain as many articles or information as you can that prove that a learning disability is something you are born with. Therefore, you might only get 2 assessments in your life. An assessment can take 8 to 10 hours to complete and cost over $1,000. Private or public insurance will not pay for a diagnosis unless it is related to another condition, such as depression or anxiety. Thus, where are you going to come up with $1,000? Medical conditions. Myasthenia gravis, lupus, and other medical conditions can get worse the older you get and are not apparent just by observing you. Most of the time, your medical condition allows you to function, but without warning, your medical condition can make you unable to function for a few hours to a few days. Therefore, you can work a job, but you cannot work a professional job. Consequently, you will never make enough money to pay your student loans. Some judges will say that since your medical condition is not bad enough for you to collect Social Security disability, then it is not bad enough to prevent you from working and making enough money to pay your student loans. We know a woman that had a brain tumor and had part of her skull taken out. It took 3 years for her to receive Social Security disability. It is not easy to attain Social Security disability. There is nothing implied in the 3-pronged test that states you have to be totally disabled. If you are totally disabled, the U.S. Congress provided a procedure that allows you to get your student loans discharged without going to court. You can fill out a disability discharge application or total and permanent disability. Therefore, going to court is a way of getting your student loans discharged for people that are not totally disabled. There have been many people that were not totally disabled and got their student loans discharged. Please see the webpage labeled Case Law for examples. Thus, some judges just use this as a way of killing your case. Before we get started, you should know that whatever medical records you submit to the court, that the people that review court documents will not care. They do not know who you are, and probably will never know who you are. You are not important enough for them to figure out who you are. They really only care about what the judge stated in a ruling. Yes, a high-paying job might look it up, But if you could get a high-paying job, then you would not be attempting to get out from under your student loans. If you become rich and famous, then you can write a book telling how you overcame your disability and became rich and famous. Thus, file all your medical records and use them at trial to prove your case. The 4 things you can do. The 4 things you can do does not mean that any of them will work, but what it does mean is that you have something for an appeal. What some judges have done is give a verbal judgment, but not put it in writing. If it is not in writing, it means that you never had a trial, never had a hearing. There is no judgment, no order, and you never submitted any evidence. Consequently, you have nothing to appeal. Hence, your case is completely killed. All of the following 4 methods will help to stop your case from being completely killed, and may force the judge to consider your disability or medical condition. 1. Know the rules of evidence. 2. File a motion using Volume 5, Section 255 of the Guide to Judiciary Policy, Services to the Hearing Impaired and Others with Communication Disabilities. 3. File a motion using Rule 706, Court-Appointed Expert Witnesses. 4. Verbally state the name of all the evidence at trial, even the evidence the judge said cannot be submitted at trial. The rules of evidence and disclosure of documents. On our website, we provided the Federal Rules of Evidence and Federal Rules of Evidence Quick Reference. Federal Rules of Evidence provides all the rules of evidence, and the Federal Rules of Evidence Quick Reference lists the rules of evidence that you probably will use. Federal Rules of Evidence. And Federal Rules of Evidence Quick Reference. Before you can submit any evidence that can be used at a trial, you must follow the procedure and use the Federal Rules of Evidence. First, you must file the evidence with the Bankruptcy Clerk Office and provide the other side with a copy. The following example of the disclosure of documents is on the website. Please look at the following example. This example is on our website. The title is Disclosure of Documents. The next line is very important, which states that you will present the following evidence at trial. This is important because you are giving the other side notice of what you will be using at trial. File all of your evidence as soon as you can, so that the other side cannot say that they did not have enough time to review your evidence. If the other side does not have 3 months to review your evidence, then the judge might not allow you to use your evidence at trial. Look at the next line. It states, pursuant to the Federal Rules of Evidence Rule 401, Rule 803-3, Rule 803-4, Rule 902-6, and 902-10, I am submitting the following evidence. This tells the other side the laws that allow you to submit the evidence. The next line, you are listing all the evidence that is attached to this document. The line that states, job descriptions for the jobs I applied for, is important because the court will want to know all you have done to attain employment over the past 5 to 10 years. They may only ask for the jobs you applied to for the past 5 to 10 years, but give them all the jobs you applied for since you left college. All the jobs you applied for, with the dates you applied for the jobs, the job title, and the job description. It is very important that you sit down and think about all the jobs you have applied to and interviewed for, and the dates they took place. The more jobs you applied for over the past 10 years, the better. This means every job since you left college, even if it was over 20 years ago. One of the tricks they use is to say that you did not apply for enough jobs, or the jobs you did apply to were way beyond your ability. For the line that says articles, you can find articles at the following websites: WebMD, Learning Disabilities Association of America, www.ldamerica.org, National Center for Learning Disabilities, www.ncld.org, LD Online, www.ldonline.org. LD Online is the National Education Service of WETA TV, the PBS station in Washington, D.C., WETA. Next, sign, date, create the certificate of service, and attach all your evidence. File a motion using Volume 5, Section 255 of the Guide to Judiciary Policy, Services to Hearing Impaired, and Others with Communication Disabilities. On our website, we provided an example of a motion requesting accommodations for plaintiff's disability. The procedure to file a motion is in Video 4, which is labeled Motions, Memorandum, Certificate of Service, and Affidavit. If you have a disability of any kind, always request accommodations, whether or not you need it. If your motion is granted, then this may force the court to recognize that you have a disability. If the court recognizes your disability, then the court has to consider how your disability has affected you when it comes to employment. Many judges believe that a learning disability is not a real disability, and if you graduated college, then you should have no problem in finding a job. Some colleges have better support for people with disabilities than others, such as tutors, note takers, extra time to take exams, soundproof rooms, etc. The college environment is different than the real world. You are not going to know what you can achieve until you try. The other problem is that the federal court might say that if you had a disability before you attended college, you cannot use this as a reason to get your student loans discharged. This is because you knew the risk that after college you might not be able to attain employment. Then you have to tell the judge the following, in writing. This is very important. 1. According to federal law, the Individuals with Disability Education Act, IDEA, helps people with disabilities graduate high school. 2. The Rehabilitation Act helps people with disabilities attend college, graduate college, and attain employment. 3. The American with Disabilities Act helps people with disabilities retain employment. 4. According to Section 504 of the Rehabilitation Act and the American with Disabilities Act, it is illegal to ask if we have a disability to attain student loans. This is why asking if we have a disability is not part of any student loan application or requirement. 5. For many of us, the only way we can afford college is by student loans. A person is not going to know what they can achieve until they try. 6. If the court makes the requirement of not being able to use our disability as a reason to attain a discharge, then according to the Individuals with Disability Education Act, IDEA, the court will be cutting off college for millions of Americans. What are we supposed to do? Just stay home and give up any hope of attaining a better life? Give up on getting married? Having a family and kids? Buying a home? And saving for retirement? Are we not entitled to this, like every other American? The accommodations you can request can include the following, but there are many more you can request. These are just a few. 1. Ask the court to allow you to read from your notes or other documents at trial. 2. Tell the court you might need more time to write your brief, your response brief, or reply brief. 3. Tell the court that you might need to go past the maximum page limits on your briefs. 4. Explain to the court that you might not be able to answer the questions or explain yourself at trial like someone without a disability. Information gets stuck in your head. It does not come out fully or correctly. Therefore, you need to write a brief that goes past the maximum page limits. 5. Your disability caused you to become mentally fatigued or confused. This is not apparent just by observing me. The trick. The Americans with Disability Act does not apply to federal court, but it does apply to state court. Therefore, the federal court does not have to provide you with any accommodations for your disability. Thus, you cannot use the American with Disabilities Act, but you can use Volume 5, Section 255 of the Guide to Judiciary Policy, Services to the Hearing Impaired, and Others with Communication Disabilities. To use Volume 5, Section 255 of the Guide to Judiciary Policy, Services to the Hearing Impaired, and Others with Communication Disabilities, you have to file a motion. The procedure to file a motion is in Video 4, which is labeled Motions, Memorandum, Certificate of Service, and Affidavit. If you have a learning disability, then you have had an evaluation or assessment. You might not realize that it affects your ability to communicate. Your evaluation or assessment might state reading, writing, or math. but it should say why you have problems with reading, writing, or math. Go through the evaluation or assessment and try to find anything that is related to your ability to communicate, such as processing speed, short-term memory issues, novel problem-solving skills, organization of thought. All of these affect your ability to communicate and understand what has been communicated to you. For everyone else, look up your medical condition and find all the symptoms it causes in regards to your ability to communicate, such as speech, hearing, concentration, focus, reading, writing, attention, processing speed, problem-solving skills, double vision, which results in your inability to stay focused. Just one of these affects your ability to communicate, and the more you have, the more problems you have communicating. The symptoms do not have to happen all the time, and no one can control when it happens. We are not going to describe the motion in this video, but we did provide an example of this motion on our website. Motion using Volume 5, Section 255 of the Guide to Judiciary Policy, Services to Hearing Impaired, and Others with Communication Disabilities. When you create your notice of motion, you must give the other side at least 2 weeks to answer and show up for court. At court, the judge will order you to write a brief, and the other side to write a response brief to your brief. Then, you'll write a reply brief. Remember, the title of your briefs will be brief. They write a response brief. Then the title of your next brief will be reply brief. We provided an example of a reply brief on our website. File a motion using Rule 706, Court-Appointed Expert Witness. The procedure to file a motion is in Video 4. Motions, Memorandum, Certificate of Service, and Affidavit. Because the court knows you have no money, this might not work at all, and the court may deny it completely. If you could afford to pay an expert witness, then you probably have the money to pay your student loans. However, someone could be giving you the money, like a charity. Plus, the court and the other side will not pay for an expert witness. Since the judge made the medical diagnosis by saying that your medical diagnosis or medical records are too old, or saying that the cost to get a new diagnosis is cheap, then file a motion requesting the court to appoint expert witness. Plus, get the court to give you at least 90 days to report to the court what you discovered. You can use the following example regarding what to say in the motion. This example is posted on our website. The goal is not to get an expert witness. The goal is to get credible information to the judge about the cost of having a new diagnosis and any other information about your disability. You can use the following websites to find an expert witness for learning disabilities. These websites might have someone that they know who will do it for free, or will provide enough credible information to the other side about your kind of disability. An expert witness can make a difference in your case. Learning Disability Association of America, www.ldamerica.org. National Center for Learning Disabilities, www.ncld.org. LD Online, www.ldonline.org. LD Online is the National Education Service of WETA TV, the PBS station in Washington, D.C., WETA. The goal is to get the other side to talk to an expert witness, and at the next status hearing report to the court the cost of a new diagnosis and what they discovered about your kind of disability. At least 2 weeks before the status hearing to discuss what you and the other side discovered with regards to an expert witness, write and file a memorandum, notice of memorandum, and notice of filing of memorandum. An example of these documents is posted on our website. You can use the following example regarding what to say in the memorandum. This example is posted on our website. At the status hearing, after you and the other side talk to potential expert witnesses, you state that this is what you discovered and ask if the other side disagrees with what you discovered. The procedure to file a motion is in Video 4, which is labeled Motions, Memorandum, Certificate of Service, and Affidavit. Verbally state the name of all the evidence at trial, even the evidence the judge said cannot be submitted at trial. The most important thing I can tell you is that no matter what the judge might have said, you must verbally state the evidence at trial in front of a court reporter. Verbally state the name of the evidence even if the judge ruled that you cannot submit the evidence at trial. If you do not verbally state the name of the evidence, it will not be considered when you file an appeal. When you file an appeal, the evidence will not be considered unless it was verbally stated at a trial in front of a court reporter. You do not know what the appellate court will think is important and what is not important. You might be able to win the appeal or have a new trial because the judge did not allow you to submit some evidence. If the evidence is not verbally stated, then it cannot be considered. You do not have to read the evidence. All you have to do is state the name of the evidence. Use the following examples. All you are asking for is to make sure you understand what the judge ruled with regards to the evidence. The judge must ensure that you understand his ruling. For example, Example 1. Judge, I'd like to make sure I understood that I cannot submit the following evidence. Then verbally state the name of the evidence, such as my medical records, articles from LD Online, my 2006 neuropsychological assessment. Example 2. Judge, can I submit the following evidence? Then verbally state the name of the evidence. Example 3. Judge, I'd like to make sure I understood that I cannot submit the following evidence. Then verbally state the evidence. Motion to dismiss. When you go to court for the first time, the other side's lawyer will try and get your case dismissed. This is just standard operating procedure. In every case, they will always try to get the case dismissed, no matter what the issues are. As long as you have some kind of evidence, argument, or issue that has to be resolved by the court, they cannot get your case dismissed. At court, the judge will order the other side to write a brief. You'll write a response brief to their brief. Then they write a reply brief. Remember, the title of your brief will be Response Brief, and do not forget to add the certificate of service. You do not have to create a notice of filing or a notice of filing a motion or an order. Look at the following example. It is only 2 pages. We're not going to review it, but there is a copy on our website. Customize this example to your situation. Reminders: one of the tricks a judge might do is not give you enough time to prepare. Judges like to get a case off the books, docket, as quick as they can. However, because of your medical condition or learning disability, you might need more time to prepare for trial. You might need more time to write your brief, your response brief, or reply brief. You probably do not have access to the rehabilitation technology you had access to in college. Thus, you will need more time. Remember to file a motion asking for accommodations for your disability. If the judge does not make a ruling on paper, but instead makes a verbal ruling, then there is no ruling. If there is no ruling on the evidence, then you can state the name of your evidence at trial. Try to verbally state the name of your evidence at trial. Remember, it is extremely important that you verbally state the name of the evidence at trial.